find any value in this, if you find any value in this presentation and wish to use any of the materials, certainly feel free to do that. I don't have any copyright on this, and as you will see, most of it is information that is generally accessible online. So, by all means, feel free to use any of the slides that you would like to use or to access any of the links that are incorporated into the slides. Okay, let me see if I can go ahead and share the screen here and get the presentation going. Okay, I think that we're on, and certainly if you have any difficulty with any of the slides, by all means, let me know. Okay, so what are we talking about? Well, basically, when I started thinking about this topic, my first thought was individuals who are preparing to retire or leave their current position and would be in a position of having to move their caseload or their clients to someone else. But as I began looking at this, it occurred to me that this topic really is broader. So we're kind of expanding this to look at why you might be in need of terminating your relationship with any particular client. And certainly there are any number of reasons for this. Some are good, some are not so good. Some are going to be determined by the client, others are going to be determined by the counselor. So we'll move through this and kind of take a look at some of these. Okay, now some of these, in addition to either counselor or client needs, are going to be determined by some external factors. And some of these can be very easily planned for in advance, and others are going to be much more spontaneously occurring. But in all cases, some type of preparation is really going to be important. Okay, so from a client's perspective, you might be terminating that relationship because they've met all the plan goals. Or you might find that they've achieved as much possible gain as they're likely to achieve. Or it may be a situation where the client's goals have actually changed. Or their situation has changed, either from a physical, psychological, or environmental standpoint. Or it might be that they just quit coming or quit responding. Worst case, the client dies. And certainly there are many other possible reasons that the client is no longer going to be actively engaged in working with you. Over the course of my career, I've actually encountered virtually all of these situations. And, it's a little bit disconcerting if you have a case management type responsibility with a client and you show up at their place of work or their place of meeting with you to find out that during the preceding days they actually died, and oh, by the way, would you like to go to the funeral, which is starting in about an hour. So these kinds of things do occur, and being prepared for them really makes that transition a whole lot easier. Now, looking at it from a counselor's point of view, possibly your caseload or your scope of practice might change, and you're having to hand these cases off to someone else. You might be the one that realizes that the clients reached their maximum gain with the services you're able to provide. On a positive note, maybe you get promoted or move to a different location. or even better, maybe you're retiring, or moving on to some type of practice. Not so good might be situations where you become incapacitated or die. Certainly one is more permanent than the other. But even in the case of a temporary incapacitation, someone else is going to have to carry on that work with that client. So there needs to be some type of planning in place about how this is going to occur. Okay, so we need to look at this in terms of some legal requirements. What about HIPAA, FERPA? What about other state or federal laws that might be governing your interaction with that client? From an ethical standpoint, both the CRCC and the ACA codes do address what constitutes a legitimate and proper termination of services. And certainly there are other codes that you may need to be concerned with. The codes from NBCC, if you're a certified counselor. If you're working in a environment, say with workers' comp or life care planning, then there's certainly going to be some other codes that you may be bound by. And we're going to kind of take a brief look at some of these. Okay, as I mentioned, kind of the process of termination does call for some type of planning. You should have some idea whether you're working in an agency or organization, or if you're in private practice, you should have some idea about succession planning. If you're in an organization or agency, there may be some very specific practice guidelines that are already part of the overall organizational setup. What about disasters or crises? Certainly, if you're working with a client with any type of special needs, looking at how they're going to handle any type of natural disaster or man-made disaster might be crucial to their well-being. Certainly, you want to take a look at who is going to be responsible for what aspects of that planning process. As part of your initial sessions with any client, you probably should have discussed what happens in a disaster situation, or what happens if you're not available and they have some type of crisis situation. So, part of this is information that you should have shared with that client up front. But if you're in the process of planning for one of you, either you or that client, then certainly you want to make sure that it's very clear about what the next steps will be and who is going to pick up that process. Also, let's say that something happens that was not particularly planned for. What should come next in terms of notification, either from that client, if the situation is on their part of the picture, or from you, or from your agency or organization if you're not going to be available. Okay, so in terms of disclosure of that change in that environment, who needs to be contacted and how are they going to be contacted? If it's not going to be someone that you're currently dealing with, then do you have the proper release forms available? If you're not going to be available to that client and you're not able to contact them directly, are there family members? Are there other people in the community that need to be notified of this? Okay, we mentioned a couple of possible legal considerations. HIPAA and FERPA are probably the two that you're most likely to encounter. But keep in mind, there are some other laws and regulations that may be specific to particular clients or particular populations. If you're licensed as a counselor, then certainly that state agency or board may have some say-so in terms of effective notifications and succession planning. Okay, here are some of the primary resources that you might need to be familiar with. These pertain to HIPAA. One is their overall privacy rule that pretty well controls protection of privacy for those clients, as well as release of information. The other two are a little bit more specific. That second one dealing with mental and behavioral health, including opioid overuse. The second one is on dealing with emergency situations. What are the responsibilities in terms of preparedness, planning, and response? Let me see if we can go ahead and go to those links. Now, this is kind of the overall privacy rules. And this goes on for a number of pages. And if you go to this link, you can get to a PDF version if you prefer to look at the printed word. But this does cover quite a bit of information. I'm not going to go through this whole thing. But it really lays out a lot of specific information that is governed under HIPAA, particularly for healthcare providers and for business associates or others that those providers are interacting with. If you're making use, yes, go ahead.
We can't see what you're saying.
Okay. Well, in that case, by all means, get at the end of this, send me an email with your email address on it, and I will send a copy of the slides to you. And if you're using the slide presentation, you can cut and paste that link to your browser and get to it. If you are using the PowerPoint show presentation, you can simply click on it and go directly to that site, look at what you want to look at, print out what you want to print out, and then just exit that and you'll go back to the slides. But we'll go ahead and get back to the slides. As I mentioned, anybody that wants to send me your email, and I will forward copies of both the slide presentation and the show presentation for your reading pleasure.
Dr. Ortega, would you like for me to put your UALR email into the chat box?
Pardon?
Would you like for me to put your UALR email into
Yes,
the chat box?
that would be fine. And I do have it at the end of the presentation as well. Okay, well, let's move on. Now, under FERPA, which is more geared towards educational facilities, excuse me, there are limitations on what records can be disclosed or shared. And, if you're working for a rehabilitation agency, more than likely you already have some agreements with the various educational facilities to share information. but there are specific guidelines that the educational facilities do need to follow in releasing any information or sharing information. And if you do not have an agreement in place, then you and the school both need to make sure that that student or their guardians have afforded both of y'all the ability to share information. Okay, and again, here are some links that talk about the overall Family Education Rights and Privacy Act, and also provide some blank forms for the release of student information that you can certainly feel free to copy and use as needed. Okay, now I mentioned there are some other laws, and just as an example, if you happen to be working with someone who is a veteran and has records through the Department of Veterans Affairs, there is a specific request for release and an authorization for release of medical records or health information. Okay. Now, this primarily is going to give you some capacity to work with individuals at various VA medical center facilities and have access to medical records that the VA holds. Again, if you're making use of the slides, you can go to those links and have access to that information about the form. There's also a separate requirement for individuals with substance use disorders, sickle cell anemia, and HIV. And this is covered under the U.S. Code 7332. And again, this link will take you to that information. But one thing that I really want to emphasize is that this is a separate release document. And so even if you have a general authorization for release of medical records, if the individual has any of these particular conditions, you do need that separate release. Okay. Any questions on any of that so far? Okay, well, let's go ahead and move on. Now, Social Security also has some very similar kinds of requirements, and this is covered through their data exchange and privacy link. And there is also a document on their website that talks about the authorization to disclose information. And, this shows their response to the HIPAA privacy rule and how they specifically implement this exchange of information. Okay, so once you get past the law, all of those requirements under HIPAA, FERPA, VA, and Social Security, and so forth, each state does have a consular licensing board, and each of those boards sets its own rules and regulations for the professional practice within its area of jurisdiction. And believe it or not, there is very little consistency here. Each state really does its own thing, and there is a lot of variation from state to state. Now, one thing that I do want to emphasize is if you were specifically named in the forms that you forwarded to or shared with Social Security, VA, hospitals, and other agencies and so forth. If you're specifically named, then that entity can go ahead and share information with you. But if your overall agency was named in that authorization form or that release form, that presents a different picture. If you were the individual named and you are no longer going to be involved in that particular case, then whoever your replacement happens to be needs to get a new authorization done. If your agency was named, your organization was named, then whoever is acting as part of that organization is probably still okay. But anytime there's a change, you need to make sure that you're still on firm ground, okay? And if you're bowing out of the picture, then whoever is your replacement needs to be reminded to check those authorizations and make sure that they are still current. Okay, any questions on kind of those legal requirements? Any comments, any particular situations you would like to address? Okay, let's move on and look at some of the ethical considerations. And we'll start out with CRCC. This is covered under Section A5 of their Code of Ethics, roles and relationships with clients. And it specifically addresses role changes in the professional relationship. And it states rehabilitation counselors carefully evaluate and document the risks and benefits to clients before initiating role changes. Now, if the rehabilitation counselor changes roles from the original or most recently contracted relationship, they discuss the implications of the role change with the client, including possible risk and benefits, which can be financial, legal, personal, therapeutic, whatever. Now, where you really get into this is if you happen to be in a role as say in a workers' comp type environment, or dealing with them in applying for VA or Social Security benefits. If your role is basically one of being a vocational expert or being a consultant dealing with that claims process, then that's one set of conditions where your role is going to be pretty much a technical role, not a consular role. And if you change to being in a counseling role, then that relationship does change. And you need to be having this conversation with the client about what that change is going to entail and how your relationship is changing. Okay, another area, A8A, competence within termination and referral. If rehabilitation counselors determine they lack the competence to be of professional assistance to the clients, they avoid entering or continuing in that professional relationship. And then B, values within termination and referral. Rehabilitation counselors refrain from referring prospective and current clients based solely on the rehabilitation counselor's personally held values, attitudes, beliefs, and behaviors. Okay, now this doesn't come up real often, but it is a point of consideration. Anytime you're looking at terminating and making a referral, then you need to look specifically at your reasons for making that decision. And the codes not just the CRCC code, but also the ACA code and other codes, typically are pretty plain about not making that change simply because you don't want to work with a certain population. Okay. You know, and it might be someone who is experiencing gender dysphoria, or it could be someone who has difficulties with substance use. It might be someone who is having difficulty because of other beliefs and so forth. And your take on it is, hey, I don't want to deal with that. Okay. You don't get to just quit dealing with that client. Okay. Now that is materially different from your not being competent in dealing with those particular issues. In which case you have an obligation to not just drop the case, but to look at gaining the competency level to be able to deal with that client on an ongoing basis, or making a very good referral to someone that is competent. Okay, so make sure that you're looking at this in terms of what that code actually requires in terminating your interaction with that client. Now, over the years, I have had occasion to deal with clients whose value system and belief system was materially different from mine. In the majority of those cases, the reason that we were interacting was not materially affected by those values or beliefs, in which case we could continue on our relationship on that limited basis that we were dealing with. In other cases, it did affect our ability to have an effective interaction. And, my obligation at that point was to make sure that we made the transition to someone who was in fact capable of working with that client in an effective manner. So, if there are groups that you're choosing not to work with, then you do need to make sure that you are at least competent enough to deal with them during a period of transition, and that you have already established some other resources that would be beneficial referrals. Okay. Certainly, in a real world situation, you cannot be expected to be all things to all people. And there are instances where referrals are going to be the most appropriate thing to do. So you need to have those somewhat lined up. Okay. Any questions, comments? Anybody encounter these kinds of things that they would like to talk about a little bit? Okay. Okay, now it goes on to talk about those appropriate terminations and referrals. Basically it says that you can and should terminate counseling when it becomes reasonably apparent that clients no longer need assistance, which is good, are not likely to benefit, or risk being harmed by those continued services. Also, if you happen to be in personal jeopardy of harm by clients or other persons with whom that client has a relationship, then certainly you're not expected to put yourself in harm's way. Now, the other appropriate reason might be that it's determined that the client is no longer eligible for your services. Okay, some other possibilities. You were authorized to provide services for a set limit of time, or whoever is funding your services decided they're no longer going to pay for those further services. And in those cases, you need to be aware of those alternate resources in your community, and that you do make an effort to smooth that transition as much as you possibly can. Okay. Now, going on and looking at that, rehabilitation counselors transfer or refer clients to other practitioners, and when doing so, they make reasonable efforts to ensure that appropriate counseling services and administrative processes are completed in a timely manner, and that appropriate information and records are communicated and or transferred to the referral source to help facilitate that transition. And this is a key thing. Abandonment is prohibited. You do not abandon or neglect clients. Counselors assist in making those appropriate arrangements for the continuation of services when necessary during extended absences or following termination. Okay, functional competence. Here we're talking about impairment on your part. And this can be temporary or permanent. Counselors are alert to signs of impairment due to their own health issues or personal circumstances, and refrain from offering or providing professional services when such impairment is likely to harm clients or others. They seek assistance for problems that reach the level of professional impairment. If necessary, they limit, suspend, or terminate their professional responsibilities until it is determined they can safely resume their work. Okay, so let's move on and look at the ACA code. Now, the reason I'm putting both of these in here, some of you may be looking at state licensure as well as CRC certification. And the codes that are referenced by each of those are different. If you're dealing with a licensure issue, going through your state licensing board, then the code that they're going to be most interested in is the ACA Code of Ethics. On the other hand, if you're dealing with certification issues, then the CRCC code is more than likely what's going to be the one they're looking at. Now, there certainly can be some other codes, as I mentioned, the NBCC, if you're a board certified counselor, if you're dealing with a forensic role, then possibly the code of the International Association of Professional Rehabilitation may be more controlling or may be a fact. But we're going to stick with the ACA and the CRCC codes for this. Okay, so in looking at the ACA code on termination and referral, section A11 has has some parts that are pertinent. A11 covers competence within termination and referral, appropriate terminations, appropriate transfer. A12 deals with the issue of abandonment and client neglect. Also, section C on professional competence addresses impairment, consular incapacitation, death, retirement, or termination of practices. And then if you're in a role of supervising somebody who is in training, then certainly F5 on impairment would be pertinent to that. As I mentioned, some of the other codes, the National Board of Certified Counselors, NBCC, has their own code of ethics, and particularly you want to look at directives 9, 10, and 23. Within the International Association of Rehabilitation Professionals, IARP, they have 9 particular areas of ethical practice, but then also have a specific forensic code of ethics, and there's also some additional standards of practice for life care planning, case management, and vocational rehabilitation. So again, make use of the slides to get to these links. And if you're going to be in any of the roles covered by those particular entities, by all means, look at what they have to say. Okay, that's pretty much all of this particular formal presentation. As I mentioned, I've got my email address listed here. And if you will send me an email and tell me that you want copies of the slides, then by all means, I'll get those out to you as quickly as I can. Any particular questions at this point or any comments?
Hey, Dr. Ortega.
Sure.
It's Kyle Kuiper. I've been serving quite a few years, sir. I had a scenario I wanted to throw at you that you bumped on a little while ago. When I was working in Florida, we got inundated with released out of prison sex offenders. I don't know what the parole officers were doing, but they were using us as a referral on their documentation. They were sending them all to us. And I kept getting...
Probably buying some time while they were overloaded. Go ahead, Kyle.
No, but I kept getting all these cases, and some of them were child sex offenders. I went to my supervisor and I said, "Why am I getting all these?" And she said, "None of the other counselors will take them." And so the old fire captain was getting all the sex offenders. And I just thought it was interesting, and that the counselors could all just say, "No, I don't work with those types." And I was like, a couple came to me and I said, "Well, we don't get the option of telling people they can't apply for services, you know," but they said, "Well, I can't deal with them." And it's just an interesting moral dilemma there, you know, ethical dilemma.
Right. And having been a supervisor in VA, of course, national program, got national rules, requirements, regulations, and all law and all the rest of this stuff that covers that. And I did have to have conversations with more than one of the counselors working for me specifically about that issue. What I ended up pointing out to them was, okay, regardless of their, you know, whatever criminal record they have, whatever proclivities they might have, our role is to look at the limitations that are imposed and look at the services they need in order to lessen or overcome those specific limitations. So regardless of the fact that this individual had been adjudicated as being a criminal as a result of there's sexual activity with minors or whatever, the primary issue for that counselor is what is going to interfere with this individual's ability to obtain and maintain employment. Secondarily, what type of environment is going to be appropriate for them? Okay, would you necessarily want to tell a sex offender, yeah, you want to go be a preschool teacher, that's fine with me? That role and that environment probably is not not going to be the most appropriate for that individual. Not to mention that whoever that parole officer is or whoever the court is that has jurisdiction probably is not going to allow that. So that would not be a realistic way to go. But there are certainly other jobs and other settings where that is going to be much less of a impediment. That may be something that you could work with that particular individual on. And for the most part, my counselors were able to look at things from that perspective and be able to work pretty effectively with clients, even though they did not like their lifestyle, did not appreciate their sexual proclivity, and looked on them as being innately sinful or not good people. What do you think? Does that kind of answer your question?
Yeah, it was just an interesting moment in my career because I've never seen this flow of people come in that nobody would work with, you know, and
Yeah.
and it was just like you said, it was a case of on each individual basis talking to each individual person as they came in to apply for services and identify what they could possibly do, and also listen very carefully as a counselor to what they were saying, you know.
Right.
Also establish communications with that parole officer real quick, you know, and
Sure.
make sure we're
Sure.
working together.
Yeah. And, you know, I think the purpose of having that language in all the codes is that they don't want counselors simply abandoning people because they don't like them. You know, they're trying to recognize the fact that, hey, you know, this is still a human being who has some needs that need to be addressed. And our charter as an agency or as a counselor in private practice or whatever it happens to be is to provide those meaningful services to the extent we're capable of.
Hi, Dr. Ortega.
Yes.
This is Terrence Boatwright. Had a class a couple times. Thank you for all your service and your help. Question to piggyback off of Mr. Kuiper, what he was saying. Is it ethical, and I hope this doesn't sound like a crazy question, is it ethical for us once we get our clients or we're able to speak to them and get them jobs that they don't disclose that to everybody? Because some people will just be like, well, I've gotten in trouble for this, and then now it's hectic for us as VR counselors to work with them to keep them employed or to so they can keep their employment. Is it like ethical for us to kind of coach them through it and say, I wouldn't necessarily advise that you give them all of that information, because some people, they get on the job and they find a friend and then they just start talking?
Yeah, I think you're right on track there. Part of the services that you're providing involve not only getting the job, but keeping the job, having that sustainability, having that ability to fit well in that workplace and do the task that they're assigned. Certainly, neither you nor they are in a position to where you're going to change the world. There are always going to be circumstances where people don't like you, don't like your background, don't like whatever you've done. So helping them with kind of those soft skills, if you will, of maybe even looking at role playing, looking at practicing. How do you respond if that employer or coworker asks, well, what have you been doing for the last 5 years? Why haven't you been working? That's not unusual for that type of thing to come up. So helping them with being able to respond to that in the least damaging way to me is part of those employability skills that you need to be dealing with.
Dr. Ortega, I do see a question in the chat box. What is our legal obligations as providers when we recognize this discrimination is occurring?
Okay. Two things. First of all, if it's illegal discrimination, then there certainly are legal remedies for that, okay? But before it gets to the point of formally looking at those legal remedies, some discussion with that client about how do you handle those kinds of questions or issues. You know, did this come about because of something they said? Did this come about because somebody in the company's HR office noticed that they had a criminal record and disclosed that to somebody? You know, what were the circumstances, and how do you work with that individual and with that employer on rectifying the situation? Now, certainly, you know, that illegal type of disclosure can be addressed under you know, various laws in a very formal manner, with a formal grievance being filed. But that doesn't always provide a great deal of help to that individual at that particular point in time. So trying to rectify that situation as best you can informally probably is the first step to take. But do keep in mind that many of these things are not legal and certainly not ethical. And trying to resolve it informally may not always work, in which case you need to know what the rest of that process is.
Good morning, Ray. This is Jim Spraggins.
Hey, Jim.
How are you?
Okay.
In
Haven't
reference
heard
to
from
the
you in a
question,
long time.
yes, I hope you are in good health. But in reference to the question about getting a referral of someone that you didn't like, basically about the sexual offenders, I was on the CRC Code Task Force back in 2016 when they revised it. They do it every 5 years. And in A4, avoiding value imposition, I can guarantee you we had hours of discussion over this. Even looked at a court case where a graduate student didn't want to work with someone because of their sexual orientation, and they actually got kicked out of grad school. But we talked for a long time about this, but I call your attention that says rehab counselors respect the diversity of clients and seek training in areas in which they are at risk of imposing their values into clients, especially when the rehab counselor's values are inconsistent with the client's goal and are discriminatory in nature. And that was kind of the compromise we ended up with. There were a lot of us that were saying we thought the rehab counselor had the right to be able to ask that the case be assigned to someone else. And that didn't happen. So they came in with this saying the counselor needs to seek training to learn how to deal with that. So
Right.
thought I would throw that in. There were a lot of opinions on that. And
Yeah.
that was apparently, that ended up being a compromise. But that's one of the biggest memories I have from that task force.
Yeah,
That was one of the
and you know,
heated discussions.
that's an issue that I don't think is gonna get resolved today or tomorrow.
Right.
You know, on the one hand, you can very legitimately look at it in terms of, you know, I don't like that lifestyle, or I don't like that kind of behavior, which is a materially different thing from saying, hey, you know, I don't know a whole heck of a lot about this particular type of disability. And I'm, you know, short term, I'm not the best person to help this particular individual deal with this. Those are two really separate issues.
Right.
Quite often, that aspect of that individual that you don't like or feel is wrong or bad or whatever is not something that is going to materially affect the particular goals that you're working with that client on. In which case, you need to divorce those two issues. Okay.
Right. I think the court.
That doesn't mean you get to ignore it. That does mean that if there is an issue that you're not capable of dealing with that client with, you are going to find other resources. You are going to make a good referral, and you are going to make sure that that transition does go well. You don't get to just say, okay, that's a part of your existence and your total context that we're just not going to deal with.
A little bit of that court case that we dealt with, it was a graduate student that was working in a practicum in a counseling center, and the religious beliefs conflicted with a client's lifestyle. And I'll just say there was a lot of discussion over that. But
yeah.
What we ended up was basically a compromise in A4.
Yeah.
So, well, good to hear from you. Good to see you.
Okay. Okay. Anybody else have something?
Okay, if there is no further questions, I'm going to stop the recording now.